Hi, in this video we're going to talk about why powers of attorney may prevent guardianship. And this is one of the most confused and complicated topics that we encounter in our day-to-day conversation with our clients. And why? And again, one of the reasons, or one of my advice that I tell people always is that the law doesn't assume that because you have family that your family members can do things for you. And most people think that. Most people think that because they are married or because they have kids, that their spouses or children are authorized to, let's say, sell property or go to the bank and withdraw money and do things for you. But that's not the case. So when an attorney tells you that, or someone tells you that you may need guardianship, that is because you never, or that person who is affected never prepared a good power of attorney. Or maybe prepared a power of attorney, but it's not good. It doesn't work. So this is what happens. Let's say your parents are very sick or ill, and you need to, let's say, sell the property to cover their cost of care, the cost of care. So what's going to happen there? You're going to try to sell the property, and who's going to sign the contract? Well, we don't know because your parent is incapacitated. So then someone tells you, hey, your parent cannot sign this contract because he's incapacitated, and that's why you end up having this guardianship conversation. And what is guardianship? Guardianship is a remedy of last resort. It's basically the appointment of a guardian by the court for a person who is incapacitated. That's what guardianship is. But you have to go through a process to get that done. And that process is very, very invasive and very costly. It costs a lot of money to get this guardianship appointed. So basically, this is how it works. In Florida, there is no assumption of incapacity, not because you were diagnosed with Alzheimer's or dementia or Parkinson, or you are in a coma, or you have a cardiovascular disease. That means that you are incapacitated. There got to be a declaration of incapacity by the court. The judge is the only person that can declare someone incapacitated. It is not the attorney, it is not the doctor, it is not the financial advisor, only the judge. And how do we do that? The family member goes and hires an attorney and files what is called a petition for incapacity. When you file a petition for incapacity, you're basically saying, I believe that my father is incapacitated. And then you file that with the court, and the court will appoint an attorney for your father and 3 doctors. Again, the court will appoint an attorney for your father and 3 doctors. Those 4 people, those 4 appointed professionals will go see your father. And they will file reports with the court. Once they go see your father, they're going to write something, and they're going to tell the judge, I believe this person is incapacitated, or Judge, I believe this person is not incapacitated. So there's going to be a hearing on that. And in the hearing, the judge is going to say, based on the evidence, I find that this person lacks capacity, and that is the point where the guardian can be appointed. And then you go through the process of guardianship. So you file a petition for guardianship, and you say, my father was declared incapacitated, I want to become the guardian. And you have to go through a background check, and you have to take a course, and you have to do a background investigation and fingerprints and all that. So it's very invasive and very, very expensive. Why? Remember, I told you before, there was going to be an attorney appointed for what is called the alleged incapacitated person, and that is going to bill the family for his service. Then 3 doctors, that will be appointed by the court also will bill for their services. So it's very expensive. I think sometimes I tell people, look, I mean, it costs more or less $25,000 to go through this process just at the beginning. And so, and how the power of attorney may prevent all that? Well, if you have a good power of attorney that was signed correctly with all the formalities, and it was signed when you had the capacity to sign, and it contains all the powers that we need for us to do the job. In other words, all the long-term care planning, all the trusts, all the personal service contract, all the Medicaid application, all the bank transactions, all the investment transaction, all the selling power, all the buying power, everything that we need to do whatever you need, then we don't need to go through guardianship because you already appointed your person that you trust. So there's no necessity to go to guardianship. Or even if we have to declare you incapacity, at the end of that proceeding, we're going to tell the judge, hey judge, we don't need guardian here because we already have a power of attorney. And that is what the law says. The judge must always find an alternative to guardianship. And an alternative to guardianship is the existence of either a trust, a power of attorney, or a designation of healthcare surrogate, depending on what is it that you need to do. Again, guardianship proceeding costs about $25,000, could be more if it's contested, if people start fighting about who wants to be the guardian. It takes a long time. So let's say it takes 4 weeks, 5 weeks to get guardianship done. You may need something before that. And it's very invasive. I mean, these people appointed by the court will go visit the incapacitated person. They need to go see you either at the nursing home or your home. And these are people that you don't know. I mean, these people are strangers. And so we have to show to the court your finances. We need to show to the court your diagnosis. Everything needs to be shown to the court. And so all of this is very, very time consuming and can easily be prevented by drafting a good power of attorney. And a good power of attorney doesn't even cost, a very expensive one may cost you what, $1,000? But if you compare $1,000 with $25,000, which way would you go, right? I mean, it's a very obvious answer. So think about that. Don't take power of attorneys lightly, especially for the elderly. You have to do your power of attorney when, number one, when you have the capacity to do it. Again, capacity to contract. You have to do it right. You have to do it with the formalities. And it has to contain the powers that we need in order to do our job. So if we don't have those powers, we can't do, and then we're going to have to go to guardianship. Again, don't fall for cheap forms. Don't fall for just a form, or don't fall for just any attorney who's going to do this. It got to be done by someone who knows about powers of attorney, the issues for the elderly or the issues for the family and things like that. We're going to talk about more details about this in later videos, but for now, please remember, a good power of attorney will prevent or may prevent guardianship. Thank you very much.